Ku Iluna, please rise. Auhea o ko e ko ka aha, inahe kuliana imua o kea aha po o kolo kolo ki ike hano hano o ka moku aina o Hawaii. E nau mai, e malio mai, I lohe ia kaleo. Hear ye, hear ye, hear ye. All persons having any business before this Honorable Supreme Court of the State of Hawaii, draw nigh. Give your attention and you shall be heard. E noho I lalo. Please be seated.
All right, please call the case.
Case number SCWC-19-00047. Frederick T. Caven Jr., on behalf of himself and a class of similarly situated persons, respondent/plaintiff appellant, versus Certified Management Incorporated, doing business as Associa Hawaii, petitioner/defendant appellee. Arguing for the petitioner, Certified Management Incorporated, David Louie. Also appearing, Ryan Louie. Arguing for the respondent, Frederick T. Caven Jr., Marjorie Bronster. Also appearing, Robert Hatch. Argument on the merits.
All right, good morning, aloha, everyone. Our proceeding today is being broadcast live on our Judiciary YouTube channel as well as on Olelo. Counsel, are you both ready to proceed? All right, we have allocated 30 minutes for each side. Mr. Louie, we're going to give you a warning light with 7 minutes to go in your initial argument. Ms. Bronster will give you a warning with 5 minutes to go. All right, please proceed.
Good morning, Chief Justice, Associate Justices. Thank you. It's a great pleasure to appear in front of you. This case is all about statutory interpretation of 514B. The intermediate court erred in several respects in this case, and I think it should be reversed. The first thing that they did that was wrong was that they found a duty on the part of the managing agent to create qualitatively different documents that are special documents for this transaction. They're unit-specific, transaction-specific, non-public information that are created for the purpose of a specific transaction. They're time-sensitive. They contain special information, and most importantly, they constitute professional intermediary opinions on the part of the managing agent to say, this is accurate data. You can rely upon it because that's what the realtors want, and that's what the escrow people want. There's two documents here. The RR 105C, I'm just going to call it the RR document for ease, and the statement of account, which is an SOA. So the RR document is a 7-page questionnaire. It is time sensitive, just like I just stated, but it asks particular questions that are non-public, such as how many owner occupants are there? How many investor occupants are there? How many people are more than a month delinquent? Is there litigation? Things like that are special information that is up to date, and it's time sensitive. They are asked to provide these by the realtor within 10 days. That's much faster than the statute requires. The statement of account is a statement of what's the owner's, the seller's up-to-date account with the association, so that there are no shortfalls, so that when you get to closing, that the escrow asks for this, and they get an update on this because this is critical information. So you get to closing and the whole transaction goes through. There's no loose ends on this thing. They have to
Counsel, wouldn't you agree, though, that all that information is related to the resale of a unit, and that's the information that's needed or statutorily required to be provided by your client?
Justice Devins, I agree that it could be read to be related to a unit, to the resale of the unit, but it is not required by the statute. It is required by private parties who say, hey, I want this information to close. The RR document is a copyrighted document of the realtors. It's set forth in the purchase contract as saying, well, you've got to provide it within 10 days.
Yeah, but 154.5 refers back to 152, and it seems to impose that obligation, if it's information, documents, whatever it is relating to the resale to help facilitate the resale, then it seems to be required. What's your take on that?
Yeah, so under 152, it says the association, not the managing agent, which is different, but it says the association shall keep financial and other records sufficiently detailed to enable the association to comply with requests. It doesn't talk about the managing agent here.
154.5 refers to the managing agent as
does
having an obligation to provide that information.
Yes, it does. But I guess the point I wanted to make in response to your question was that it says shall keep financial and other records sufficient to comply with requests. So just like in answers to interrogatories, an interrogatory says, well, give me all this information. And the concept is, well, I'm going to give you a whole bunch of documents. Okay. And that will satisfy the obligation.
Isn't that an absurd result, though? You're going to give them 10 boxes of information, say, go through all of that, and then try and fill in all these boxes? I mean,
and that's
that
why
seems to be what the argument is, where it seems to be going.
Well, exactly, Your Honor. And the reason why is because what is being asked is a professional intermediary verified opinion that this is the complete package. These are the most up-to-date documents. So this is not just the association saying, okay, I'm going to pull off the shelf all the documents here. Here's a box of documents, have it. Now what they're saying is they're going to the managing agent and saying, I want the up-to-date verified documents.
Which only your clients would have, right?
Well, the association has whatever it has. And there's a separate association website which has all of these things on it, but they don't check it regularly and they don't keep it up to date. Associa, as a managing agent, has a separate website, a different website, which
But is that true of most condominiums? Do most condominiums have their own websites?
to my knowledge, many do. But I don't know that, I wouldn't say that I know what happens on all
And
condominiums.
connected to that, I'm wondering, I took a look, but I didn't, is the contract between the association and Associa in evidence?
It is not.
Okay, because so it's not.
It's,
So we don't know what delegation of duties there may be in that contract.
I know what they are. I've reviewed that contract, but it's not part of the record, and so I can't talk about it
Okay.
really. Okay, but I would say this, there is a distinct difference, which the intermediate court did not recognize, between a principal, such as the association, and an agent, such as
But there's
Associa.
a lot of, I mean, we're talking about it in general. This appears to be a really large association, but there's a lot of smaller condos, smaller associations, and it
True.
seems that, you know, they don't have their own websites, and the associations basically handle most of this stuff for them. I mean, I'm sorry, the managing agent handles these things.
And that's certainly possible, and I imagine it does occur for smaller associations, but I know in this case, the association there is a separate website that's maintained for the association.
So everything except for the RR document and the SOA was available for free download through the association's website here.
Yes, but not through the managing agent website. Because there was a charge for that, because, and as I mentioned.
Is there anything on the managing agent's website that says you can get these documents for free through the association's website?
I don't know, it's not part of the record as to whether that's on the managing agent website, but there clearly is a separate website, and if the owner goes to that, they can get it for free. If they go to the managing agent Associa website here, then what happens is you get this menu. Do you want to order these documents? The complete document package. Do you want to order this, the RR document? You check off the boxes. There are standard charges that apply, and they order it. And that's what they do, because they want a verified professional intermediary, essentially a trust agent. The realtor and the escrow people say, I want to rely on this for liability purposes, and that's in the record.
Do they make representations? Is there like a warranty or guarantee by Associa that the information is correct? Are they
No.
subject to any legal liability for that information?
There is no guarantee or warranty that goes with this. They provide that, but as I'm sure you all know that doesn't stop anybody one way or the other from suing if there's an error. And errors have occurred in transactions, and when an error occurs, somebody will go back to the managing agent and say, hey, what the heck? Fix this, pay for it.
So when you say it was all available on the association's website, but not in the form of that RR document?
Yes, the RR document, and that's
In other words, the underlying information is available to create the RR document on the associate. I'm trying to understand when you said that, what you meant.
see. So the RR document is a 7-page questionnaire that asks for a lot of stuff that is, in fact, is non-public and may not be in the specific in specific records that the association itself keeps in the ordinary course, such as the number. Such as, let's say, construction litigation or certain things like that. But that information is available, although you'd have to go hunt and peck and search for it to find out how many owner investors are, how many owner occupants are there, how many owner investors are there, how many people are more than a month delinquent, and that changes on their accounts. That third one changes every month because it's a constantly moving ball. So qualitatively, both of these documents are different from normal records, which are kept in the ordinary course.
Does that mean that then an association can decline to provide the RR 105Cs and SOAs?
I think an association could do that because there is no mandate that the association do anything than provide its financial records.
But then wouldn't that sort of conflict with the legislative purpose of the whole chapter, which is to provide all information, all records related to the resale of units?
I think I would distinguish between the legislative intent, which is, it's a very broad statute which sets up condominium regimes, the authorities, what's the duties of the, it's very broad, but particularly for transactions, the purpose is to convey all these readily available documents which are pre-existing. That is how I read it.
There's no language about pre-existing in there.
Correct.
What it talks about is all financial records, information. If we talk about broad, it seems pretty broad there.
It does not say all financial records, but it does say financial records.
It actually says all.
Okay.
Under 154.5, it says all financial and other records sufficiently detailed is the exact language.
Yes, I stand corrected. I apologize.
And it's not only information, it's disclosures. And as I see the RR form, that's just a bunch of disclosures and checklists. It doesn't seem that burdensome, but that does seem to be vital information relating to the resale of the unit. And your position, I guess, that they do not need to comply with that request, wouldn't that hold up sales and defeat the whole purpose of the statute?
If you didn't, so the question really is, Justice, I think, do you have to create new documents, new opinions, and verify them and take on the liability risk for that upon the request of somebody? Or can you provide the documents? The documents themselves have to be kept, and those documents can be provided. Now, if private parties want to ask for a specific request of information that may or may not be in the records, if it's in the records, they could do it. But does a managing agent or even an association have to go create a special document?
So
you could read it that way, though.
But then, so we're talking about, accepting, possible liability. Then, every transaction that's going on, transactions that are going on right now, they're assuming liability. They would be, right, if they're preparing these RR forms.
Yes, everybody is assuming liability. Not every managing agent provides an RR form. Ms. Pembroke said that in her deposition. Docket 33, 869, PDF 869 to 899 is her deposition, and she talks about the cost. There's a $185 cost for the RR document, and she talks about how not every managing agent does that. So, is that created? The problem with, and I grant you that a broad reading of this statute can say that information includes anything related to a resale. But that would allow outsourcing of the duties of a statute to private parties. If the private parties decide, well, I want this, and here's my contract, and now that's required for the transaction.
What does the contract say? Is it the seller to
I'm
provide?
sorry.
In terms of the contract, the DROA is, who is to provide the RR document? The seller?
The seller is supposed to provide that, yes.
Okay, so if the, under 514B, 154.5 A1, if all that information, like what, whether each unit was, each specific unit was owner occupied, and what the percentage of common percentage of that they, each unit was allocated for common area expenses, and whether each unit was, and what the annual, what the common area expenses were or anticipated to be. If everything was there, the realtor could complete the form on
Yes.
behalf of the seller,
Yes.
the seller's realtor, or the seller themselves, if it was owner.
Somebody could do it, yes.
Somebody could do it.
And what they
But
want,
is that information all listed by associations
not, I
or
don't know if all,
managing agents? I mean, it would have to be continuously updated, right? Like, okay, this unit now is no longer owner occupied. How do you even know once a unit is sold whether it's being rented or not?
I think they ask some of these, some of the managing agents ask these questions, and that information shows up. But I don't know exactly on that. But the information is available, but again, as you've pointed out, it has to be continually updated. And that's essentially what they're asking the managing agent to do, is give us updated, up to the moment information. You know, the statement of
But you know
account.
what, but Council, I guess what's, a little troubling is that the information that seems to be asked from at least the RR seems to be information that's in the control and possession of the AOAO. And then you have 154.5 that puts the affirmative statutory obligation on the managing agent to provide all financial information, but also other records sufficiently detailed in order to respond to the information requests related to the resale. So it's to facilitate the resale, but it's an obligation on the managing agent. It's not really creating, isn't it? Just they're providing information that they should already have.
Well, they
In
don't.
the RR, you're just checking boxes, and it's really information that seems to only be with them. And then you have a disclaimer at the end. So if there is a liability concern, there is a disclaimer, isn't there?
Well, there's a disclaimer, but this court and other courts have held that disclaimers don't always apply and don't always work.
But the fact is, there is one.
There is one, certainly one. There is a disclaimer. But the point is that there's a verification here. You have to do more, especially for the statement of account. Yeah, and there were 2 updates, not just, it was ordered, and there was 2 updates requested, and they say update right before closing. And that's what they want, because they want an up-to-the-minute one. What's the account? Have there been any additional
Isn't that pretty standard,
charges?
though? in
It's pretty
closings?
standard,
Right.
yes, it is. And but you have to go do something about it. And you have to then say and provide essentially a professional opinion.
The ledge seems
This
to have
is it.
put that obligation on the managing agent.
Well, I don't think that, I mean, you could read it that way, I will grant you that, a broad reading of that.
154.5 seems pretty clear on that, right? It says the
154
managing agent, along with the association, has that obligation.
I think it says that the managing agent has the duty to provide, to make available all financial and other records. And so I would just point out the plain language of the statute talks about, it says the following. You have to provide the following information, and then it lists.
But also in sufficient
Yes.
detail.
Yes, but it then lists 14 different types of documents that are all documents that are normally kept in ordinary course. It doesn't say you have to go create new documents, and the statement of account is created specifically for this transaction at the request of a party. The RR is
But the
specifically
statute,
created.
the statute we're quoting from was enacted in 2014. So the legislature, with all of this background of the other provisions, all the history, and there is a history of, conflict between condo owners and associations. And in fact, the bill that resulted in 514B 154.5 started out very differently. So there was a lot of conflict. And this provision that we're talking about today came in relatively late. But when it came in, the committee report is very clearly trying to protect the rights of condo owners to get information and documents. And then Section 1 says very explicitly, all financial and other records sufficiently detailed in order to comply with requests. So can't that reasonably be read to incorporate the creation of these documents?
You could read it that way. That would be a broad reading of it. We think that a more moderate reading is in order to say that that pre-existing documents are required, but that the creation of new documents and the providing of,
Sir,
of a professional opinion.
We don't allow filming in here if you're filming with your phone. Sir, yeah, thank you. All right, I'm not sure if you're filming our oral argument, but we don't allow that if you are. Thank you. Thank you. Sorry to interrupt, Mr.
No problem. But so your question, Chief Justice, was whether or not 154.5A1 talks about all financial and other records sufficiently detailed, and whether you could read it broadly to say that means you have to create documents. I think that a more moderate interpretation would be better, because otherwise, let's suppose that two parties agree, well, you need to, there's some construction litigation. I need a 50-page analysis of that construction litigation, and that's required for the sale. And now, is that duty on the managing agent just because two private parties have agreed to?
Related to that, I have a question as to 154.5 subsection H. Nothing in this section shall be construed to create any new requirements for the release of documents, records, or information. Is there anything in the briefings that explains what documents, records, or information was required to be provided as of the time of 514.5?
Well, so the difference at the time of 514.5, which is new, which is under Act 188, okay, that added the word information. Prior to that time, there was only 152 through 154. And 152 through 154 basically talked about pre-existing documents.
The declaration,
it didn't
bylaws.
say, but it listed all these documents, which are still listed in 154.5. So 154.5 is a whole new thing, and it's there to, if you read the legislative history, it's not particularly helpful. But H specifically says, as you've pointed out, that it's not intended to create anything new or new obligations or.
So you would argue that some of the things that are being requested now here is new information, would be considered new information under 154.5A1.
Yes.
Where it says sufficiently detailed to comply with the request for information.
Yes, that's how
So there's a real ambiguity here.
There's some ambiguity. I don't think the legislative history addresses it completely, other than the explicit statement of H that you've said, which is we're not creating anything new.
One of the things that in A of 154.5 is they put all of the individuals or entities, managing agent, resident manager, board through a board member, or association's representative, all in that prelude paragraph. Whereas, and so this is the new statute in 2014, whereas in 154 and 152, it was much more specific as to who had the responsibilities, right? So, I mean, I think that's part of the challenge and the ambiguity in terms of what's stated in the plain language of the statute and what's in H and what's in the legislative history, that they weren't trying to create new duties. How do you read that? I mean, how are we supposed to parse all of that out?
I think that since they weren't trying to create new duties, we stay with the duties that existed and the regime that existed, where managing agents provided this as an accommodation, which they've continued to do, and they would assess a reasonable charge. I understand that you could read the requirement broadly, but I think it goes too far to say that it is that you have to create new documents and then provide verified opinions, which at the behest of third parties who have a private contract.
Do
Mr. Louis,
realtor-
oh, I'm so sorry.
Oh, I'm so sorry, CJ.
No, I was going to jump to another topic. So I know there's another argument that is presented by the briefing, and that relates to 514B 154.5E, which talks about an association's ability to provide documents for download at no cost to the unit owner. And I believe the argument here is, or the question here is whether that provision applies to the managing agent in these circumstances or can apply to the managing agent. I think your argument is it should not. So if you could talk to
Yes,
us a
thank
bit
you,
about
Chief
that.
Justice, and I notice my time is
Yeah, you can
getting
keep going,
compressed, but
yeah, we'll give you the chat. I wanted to hear from you on this
that's
point.
okay. But I think that's an important point, and that is really I would say an egregious error by the intermediate court to say that the duties of an association which are explicit in 154.5E, which says an association. It doesn't say managing agent. It says an association shall provide documents by internet by free. So the intermediate court said, well, there's really no distinction between associations and managing agents. And I think that belies 514B-3, which defines the two of them as separate entities. It belies 102 through 107, which are the duties of an association. It belies 132, which is the specific duties of a managing agent. And it ignores a whole body of law that this court has engaged in that sets forth that principals and agents are different. They don't have the same duties. And there's a lot of stuff on that. And also, just to conclude on that, is so the intermediate court ignored all of that and placed that duty on the managing agent, but it creates an absurd result. And there's two absurd results. The first absurd result is, so the managing agent could provide documents and this opinion, if you read it broadly, and make a reasonable charge under 105D as long as it sends it by mail with an envelope and a stamp. But the minute it posts it on an internet for download at the request, because people want their transactions to go through fast and they want the documents instantaneously, suddenly that has to be for free. That is absurd. If that goes forward, then we're going to go back to snail mail. We're not going to have internet downloads for documents because nobody would do that.
Wait, but it wasn't one, it's seemingly an idea, or at least an underlying positive to subsection E was kind of a win-win. I mean, the association can put these documents, their bylaws, their minutes, all those types of things online for download. And that avoids, seller coming down to the office, banging on the door, the big hassle of all that and copying and so on and so forth. So the association wins there. And on the other hand, the seller wins too because of the ease and the freeness. And it's only may comply. They don't have to. So, I mean, can you explain, I guess, what the big problem then with E, whether it's managing agent or association really is, when it seems to be that statute was a statute of convenience that helps both sides?
I think the difference is when you place that duty on a managing agent, that now while the documents may be easily ascertainable, the managing agent undertakes to keep them up to date, to make sure that they have the most complete package. And Ms. Pembroke in her deposition, which is at docket 33, 869 to 899, talks about how they want the most complete package for their liability purposes. They don't want to miss a document. They don't want to have something fall through the cracks. And what the managing agent is doing, which is different from what the association is doing, is providing that and essentially providing a verification that's saying this is up to date, this is the most complete information. So just to conclude, I think basically the Intermediate Court of Appeals got this wrong. They read the statute too broadly. I think the plain language says that these should really be read as existing documents and not creating a duty of creating new documents with a verified opinion. So I think that goes too far in the reading of it, but I understand you could read the statute more broadly, and you could say all information means all information of any sort. But that leaves open the questions of whether or not private parties are now creating statutory duties because they're saying, I want this for my resale. And the guy agrees. Now the managing agent suddenly has to comply. So that's one problem. And then the second problem is the one that you just asked about, Chief Justice. And I think that's an absurd result to say that the managing agent, on the one hand, can provide it for a reasonable charge, but if they do it by internet, they're no different than an association. So I'll reserve the rest of my time for rebuttal. Thank you.
All right, Ms. Bronster, your argument.
Thank you very much. I think it's pretty clear that we are talking about 514B and what happened in 2014. But I think that some of the arguments go only to the issues relating to the ICA. And I think as we come before you, I think all of the issues that were on appeal from the circuit court are properly to be considered. So we believe that some of the errors that I will be talking about actually go back to what the circuit court did with respect to the errors.
Are these matters that you raised in your cert application, though?
No, we did not have a cert application.
Oh, I'm so, pardon me, excuse me.
They were
But you
raised
didn't
in the
do a
appeal.
cross-app,
Yes.
right? Yeah, okay. I'm sorry, you didn't do a cross-app.
No,
though.
we did not. But I think a little bit of a history as to 514B 145.5 is appropriate. And I think if you understand the history, it explains a lot of the questions that have come up, and hopefully I'll address them, and otherwise I'm sure you'll let me know. But in 2014, we already had 514B 152, 153, and 154. And it already put obligations on the managing agent. The suggestion that the managing agent is not obligated under statute to provide information and documents is simply not true. And it existed prior to 2014. So what 2014 said, what they said in 2014 was, we're passing 154.5, and in H, they're saying we're not requiring any new documents to be created. We're just clarifying what was already there. So if you look at the old 154, which was in existence, in 154D, that specifically said that the managing agent shall provide copies of association documents maintained pursuant to this section, which was 154, and sections 152 and 153 to the owners. So the obligation of the managing agent already existed before the clarification in 2014. And 152 says that the association shall keep records and, financial and other records sufficiently detailed to enable the association to comply with requests for information and disclosures.
How do you address, though, in 154D, which you initially pointed to, that, that specific provision talks about providing copies of records maintained. So I think with
Right.
regards to the question of creating the RR document and the statement of account.
Okay, and I think when you look at the wording of 152, it deals with, and this is even pre the 2014 amendment, the association shall keep records and financial and other records sufficiently detailed to enable the association to comply with requests for information and disclosures. So they weren't supposed to provide just documents that existed. It was to provide information. And the clarification came in 154.5A. And if you look at that language, it makes it clear that it's not only documents that were kept. In the preface, in 154.5A, it says, notwithstanding anything else, the following documents, records, and information. So it's not limited to what already exists. It says the following documents, records, and information, whether maintained or kept or required to be provided pursuant to sections 152, 153, or 154. So I believe that the legislature was saying in H, we're not creating anything new. We're just clarifying what we always believed was already supposed to be done. And if there was any doubt as to whether D in 150, the old 154, applied to managing agents, they spelled it out and they said that has to be made available.
Made available, that's right. I mean, I think that language
Correct.
is an interesting use of, phraseology too. I
Well,
mean,
it says made available by the managing agent, the board, or the association. And then it goes on to reiterate that it's the information sufficiently detailed to comply with the request of information and disclosures related to resale.
Okay, but does that require them to actually have to fill out these forms and sign them and attest to them and provide that to the unit owner?
I think it's required to give them adequate information. If they had their own form that provided adequate information for the related documents, that might have been enough. But the association, the Regency, and Associa provided the RR 105C.
Okay, but do you agree that all they're required to do under the language under your reading is just to provide the information related to the resale?
Yes. Yes. But at no time did Associa ever say, we will not provide you the information or we will not provide it on this form. They did. They did it with everybody.
It might be easier for them to do it that way.
And if you take a look at the document, the RR 105, I think it's pretty clear that it is a pretty standard form. It's not something that changes day to day. Most of the questions are things that you look at and you see, that they're pretty standard. It's at volume 7, ROA, page 144. And the argument that Associa makes is that if it is kept, that's the only thing that has to be provided, that they're not required to create anything.
what about the argument, though, that Mr. Louis makes that, we're talking about information and disclosures related to the resale of units. There's a specific condo here, one condo, right? What about in other situations where for the resale of a property is much more complicated and it's much more involved, and in the contract between the buyer and seller, more complicated information is required for disclosures related to the resale of units. And I think the question, the real challenge is the ICA's holding that there is a statutory duty of the managing agent to create those documents.
And I think that that's because when you look at sub A, it talks about information that is required under the statutes.
Right.
It doesn't say kept. So I believe that it does create the obligation to create documents or to put the information in some sort of accessible thing for the owner and the agent, and they can either do it by putting it on the website.
You keep saying create, but you're just providing the information being requested, right? I mean, what's actually being created? They're giving you a form, you fill it out, and you're giving the information that you should have.
And
right?
Justice,
the managing agent should have that information, right?
You're absolutely right. I agree with you. I was trying to address what Mr. Louis was arguing.
No, I understand.
And quite frankly, I think one of the biggest problems with Associa's argument here in the briefing below is the fact that creating is not a word kept that's in the statute. Kept is only one of a list of things that are in the statute.
But you know, Mr. Louis is also arguing that these are new burdens that are being placed on the managing agent, and the statute makes clear that there's no new requirements that were created by this. How do you answer that?
Because they already existed in 154 before 154.5A was passed. In 154 sub D, it already put on the managing agent the obligation to provide the information required under 152 and 153 and 154.
The statutes seem to have required that information or documents be provided. But in terms of the RR form, it is a highly individualized calculation, right, as to the specific unit. Let's say that the unit was being sold through an estate proceeding or something, and then, you know, the association, the owner, the previous owner, there were deficiencies in the payment of association fees, and perhaps there had been a lawsuit for collection of those fees, so therefore there were attorney's fees associated, you know, with that unit and things like that. I guess that would come through the seller's portion, so it wouldn't come through it wouldn't be attributable to the buyer. But I mean, to the extent that, you know, the sales price didn't cover everything, you know, I mean, there's just a lot of stuff that the association might have to provide, right? I mean, why shouldn't the association be compensated for having to compile all of the specific information regarding the unit? And especially like now with trying to anticipate what additional insurance payments have to be paid, right? There's a lot of associations that are having to pay unanticipated insurance expenses that are now being allocated to the units, et cetera. Isn't that a kind of a highly detailed thing that associations have to go through, or managing agents have to go through?
Well, frankly, whether it's complicated or not, whether it's a burden or not, that was a decision that was made by the legislature well before 2014, that managing agents are required to do this. And managing agents don't.
But all they have to do is post it. They may provide the information online so that it can be downloaded, or F says any fee to obtain copies shall be reasonable, provided that a reasonable fee shall include administrative and duplicating costs. It doesn't seem like the information that was previously required to be provided required the association or a managing agent to specifically calculate what was required. Or is that something that escrow does? I'm a little bit confused.
It's actually, generally what escrow does is if they say that the outstanding amount is X and we're closing mid-month,
right,
then they can prorata. So they can do the calculation of a daily rate.
right.
But what's important is that the information about what is owed by this owner of this unit, that is in the financial books and records of the AOAO. And it's just information that is provided. Did they pay the monthly rent or the monthly assessment? Are they past due 3 months? That's all in the financial records. And it is simply a matter of providing it.
So in terms of the charges that were assessed here, it wasn't actually for $1 per page for copies received. Is that right?
No, that's
They
correct.
just charged what they thought was reasonable for compiling the information that you requested.
Correct. I mean, if you look at the statement of accounts, which are in the record at volume 8, ROA 110 and ROA 113, it's pretty clear that they charge $286.46 for each of the condo and the community association. And the second page of that document, it's just one page. So the first page is the invoice, and the second page is simply that the outstanding charges, the maintenance fee was monthly charge $560. So it showed the invoice as to how much that particular unit owed.
Can I ask you, your position is that it should have been a $1, it should have been a $2 charge, or it should have been no charge, or it should have been something less than 286 but more than $2?
Well, it should certainly have been less than $286, but we believe that it should have been no charge because it was downloaded. All it was the agent going online, pressing the button to get the information about this particular unit. It wasn't separately, there's no
What if it
evidence.
was mailed to you? What if it was mailed to your client?
If it was a copy that was mailed, we believe that the statute would allow a fee for mailing and no more than $1 for the page.
Even
So
though,
you're- I'm sorry, go ahead.
even though somebody in the office may have had to go through the books and spend time to pull the information together, they can't recover for that? I'm just asking what your position is. I'm not expressing an opinion.
Right. No, I mean, I think that it's pretty clear that the $1 a page is the maximum that is allowed under the statute.
So they can't recover.
No, go ahead. I'm sorry,
Yeah,
sir.
I had something I wanted to ask, but yeah, and then I'll turn it over to you, Justice Devon. So they cannot recover the costs of preparing. So what about the cost of preparing the 7-page document, those answers? Somebody's got to sit there and go through the form. Is that, that's a $7 charge, or should it be more if it actually takes somebody time to?
I'm sorry.
No, go ahead.
The statute says a reasonable charge to defray any administrative or duplicating costs. But our position in this case, based on these facts, is that there is no charge that is allowed because it was downloaded. Had it not been downloaded, there may have been other things that we would be talking about. And
Right.
maybe we
But
would
if
have to
don't
have a
agree with
trial.
if we don't agree with you on the other issue of whether managing agent or association is covered by the download provision, then we do have to address these issues, right?
Correct. And on the download, on whether or not the association is covered by the download, or whether it's only the association or whether it's the managing agent as well, I think you have to look at the cross-referencing. Associa and the court below looked solely at the word association and said, well, that's it. The managing agent isn't bound by that. And that was the argument that we heard Associa making in conjunction with the interpretation of 154.5E. But he also made that argument with respect to 152. 152 says the association shall keep records, et cetera, and make them available. It doesn't say managing agent in 152. But if you look at 154D, it says the managing agent shall provide the documents pursuant to 152 and 153 and 154. So there's a cross-reference that makes association in 152 applicable to the managing agent. Now,
Because they delegate that responsibility to the managing agent?
no, because the statute does it.
I see.
And the statute does it. And then in 2014, 152 was amended. And it said the association must make the information available pursuant to 154.5. So if the managing agent has to follow 152, in 2014, it also was required to follow all of
So,
154.5.
but when you're talking about those duties, are you specifically alluding to the definition of a managing agent? Because that says they're managing the operation of the property, and the definition of operation of property includes administration duties.
No,
Is that
actually,
what you're relying on, or is it
that's
something
that's
else?
not what we're relying on. What we're relying on is the old 154, which was existing before 2014, D, which says the managing agent must provide the records pursuant to 152, 153, and 154.
But isn't all this compiling and providing records, isn't that part of administrative duties?
It certainly is. But I think what the legislature wanted to do was to make sure that it was more specific than simply general obligations.
Can I ask you if it's, say it's a $30 million condo down somewhere in Kaka'ako, and they're very sophisticated lawyers representing the buyer, and they want all kinds of information. They don't just want the RR form. They want certified audited financials, assessments of, various costs and expenses way beyond what the RR document provides. Would the association, and say there's 30 pages is the outcome of that, is that $30, or can it be a larger charge? What can they charge? So in response to this very, very detailed request for information, it takes, lawyers on the other side, lawyers for the condo association or lawyers for the managing agent, who have to spend hours and hours putting the information together in order to comply with the request. Whose expense is that?
Well, the expense on the contract, that can be altered. I mean, if somebody wants a full opinion on what this.
You get what I'm saying? In other words, this is in some ways, this case is relatively simple because you have the RR document. Your argument is, hey, it's a simple document. Someone's just got to sit there, fill it out, super easy. I'm saying, what if the request for information is more detailed and it actually does require significant effort by the association or the AOAO to fill it out? Who pays for the cost of undertaking that effort?
If it is downloaded, if it is simply something that they can pull off their records and download, there's no charge. If it is simply copying something, then it can't exceed $1. And if you go in to the statute itself, it has a whole list of different records that have to be made available. Payment vouchers, accounts, receipts and expenditures. I mean, it goes on and on and on. And I think you'd have to look at each one of those to see whether it was contemplated. If it was outside of the contemplation, then I think you'd have to do an analysis of what is a reasonable administrative
Because
charge.
can't that provision on reasonable fee be read that $1 per page is just a qualifier for the duplication cost as opposed to the administrative and other work that may go into it? Because you're talking about $1 per page. I mean, that's really duplication, not so much the administration. It could be read that way, couldn't it?
I think it could be, but I think that,
Wouldn't that be
but
a
they
more
say-
reasonable interpretation?
well,
Reasonable fee?
if you look at subparagraph F, which talks about the dollar, it says that a reasonable fee shall include administrative and duplicating costs and shall not exceed $1 a page or portion thereof, except for pages that are larger. So if you're looking at that, then the question is whether the $1 a page, if you look at it without any commas in that sentence, you would read it to believe that the administrative and duplicating fees
Because
can't
154 goes on to say, and I think it's subsection J, that if it's a different size page, you can actually exceed $1 per page. So
correct. So I'm
it seems
sure
to be qualifying just the duplication costs as opposed to the actual manual work that may go into preparing all these documents, doesn't it?
I don't think that that's how it's written. I would think that that's a logical thing that could have been done, but I don't think that's what's written on this particular page.
Thank you.
To get back to a question that was asked earlier, I did want to mention that the AOAO management agreement is in the record at 7 ROA 352.
And what is there anything about delegation of duties in that?
Well, I don't know that it's delegation so much as it is an outline of all of the obligations that the managing agent has by way of contract. And what is not
Because that's one of the documents that's required to be provided under 154.5,
correct.
right?
Correct.
And is there anything relevant that you see there to these proceedings?
Yes, Your Honor. I think that as we described, and we have it at page 16 of our opening brief, we comment that with the exception of the RR 105C, all of the documents that that were in the Regency AOAO package that Mr. Caven was charged for were documents that the association was already required to maintain under the contract with the AOAO. So, so the statement of account, everything else was required both by.
It seems to me it would be pretty typical for a lot of associations that they would require the managing agent to maintain all of these documents.
Correct. And so the RR 105 was the only document that was not referenced in that contract.
One 154.5 talks about copies, and it seems like if they were to provide copies, and it's E says you may, but you're not required to post everything online. So otherwise, the association could, the managing agent could just provide copies. And if you were to get copies of everything at $1 a page, that would be a lot more than what was charged, right? Like the declaration, board, the bylaws, the minutes, all the financial documents as to what the, and who are the owners of each unit, et cetera, right? I mean, that would be pretty cost prohibitive at $1 a page, right?
Well, I think a lot of people would think that $1,300 or $1,100 is pretty cost prohibitive as well, and that they're stuck.
Mm-hmm.
They need to sell their apartment. They want to sell their condo, and they need to provide this information.
And in order to
order to
provide
s-
it within 30 days as required by the law, as a practical matter, you kind of need to post as much as possible onto the
And
onto a
you've got
website.
and if you've got to pay the money, you've got to pay the money. And what I think Associa and other managing agents, they don't want to be subject to this law, even though they are. And they don't want to have to do this work, even though the legislature required them to do so. But it's a way that they can make a lot more money. And, if they want to make a lot more money by simply charging for something that they're not even involved with, they're just
In other words, your position would be that the associations need to pass on the expense of creating these documents for resale to the association as a whole.
well, presumably they know what the law is. And they have set their fees with the AOAOs, knowing that they have to follow the law.
That comes back to my question. What if it's a very burdensome, detailed request for information? They're stuck with $1 a page? That's what I'm asking. I'm just asking what your thought is. And
I think the way the law is currently written, yes. And if they thought that that was unfair, then they would go back to the legislature and say, I think you miswrote this because you can't possibly mean that there's no charge. But
Or-
what I think what the legislature must have realized was everyone was getting this information by a download.
Or the fact that it's limited to $1 a page informs how the statute is interpreted, right? I mean, because even going back to your 154D, it talks about the managing agent providing copies during normal business hours. It all contemplates like, here's a bunch of paper, you got to provide it. I mean, why is that not how this statute should be read, as opposed to then requiring Mr. Louis' language is professional services, essentially, to go through those documents to come up with the information that is really needed for the resale. So that dollar a page, I think, some can be read to simply providing the paper documents.
And that may be, and I think that the hypothetical of how much work is to try and figure out insurance claims or whatever other claims is really not before us today. And I don't mean to suggest that it's not a relevant inquiry. My point is that if there were a case where the association said, this is well beyond the scope of 154, that whole long list, this just goes way beyond, and that's not what's required of us. So we're going to charge you thousands of dollars to do that. That would be a different question. But there is, as I said, a very long list of things that are required, and the legislature puts the obligation both on the association and on the managing agent.
And let me ask you what the legislature understood, because I guess about 15 minutes ago you were getting into the RR 105. And as I look at the RR 105, that was a document that was in existence before 2014. I mean, the form itself says it was revised in 2010. And so, I mean, help me out here. I mean, was that sort of a common document even before 2014? I mean, this is like a standard resale document that the legislature understood was in place, wasn't it?
I believe that's right. And I believe that that's why in 152 they say, provide all of the documents and information related to the resale of units. Because this was a problem. There was a problem with all of these owners just feeling that they were being gouged, having to pay for something that seemed like such a simple issue.
And you're not disputing the fact that, you know, that they if it's not downloadable, that they can charge a reasonable fee for the RR 105.
If they did not download it, correct.
No, I thought it was $1 a page. I'm sorry. I thought your argument, that's why I was asking.
I'm sorry. A reasonable fee, which under F
is $1
would
a
not
page.
exceed $1 a page. So the reasonableness could be less than $1 a page.
Gotcha. We've been peppering you with questions. Do you have anything? We're over your time, but if you have anything you'd like to sort of wrap up with before we get back to Mr. Lewis.
I think the only thing I would like to reiterate is that when they amended 152 in 2014 and referenced 154.5 as applying to not only associations but also managing agents, it made 154.5E relevant to managing agents, even though it wasn't specifically enumerated, but it was the cross-reference that made that happen.
Very odd, though, to be sort of walking through and you've got association and managing agents in the same different provisions in 154. I mean, it's almost kind of random under your point of view, right?
No.
One provision it's managing agent, another provision it's owner, it's association. I mean, so it just seems very, very odd that they would sort of jump between one or the other. I mean, I understand you have an argument to the contrary, but how would you answer that observation, which I think was at the core of what the ICA was saying?
Well, but the ICA came out and said that it did apply to managing agents. But so they came out, I think, on the right side of this. But the way I would answer it is that's always how this statute was set up. Even in 152, it said association, and then in 154, it said, by the way, managing agents, if you're doing this work, you're going to be subject to 152, even though your name isn't in there. And so when they amended in 2014 and had limited changes, it was consistent with how it had always been read. I'm just looking at the statute. It's a weird way to draft a statute to say
And I'm not saying that's not, that the legislature never does weird things when they draft statutes in a good way.
Well,
But, you know, managing agent in D, association in G, managing agent in H, you know, it seems like, why wouldn't you just clean the language up and be consistent throughout? And the argument to the contrary is that was a choice. For some reason, there was a deliberate choice being made there in terms of who could take advantage of or follow this website approach. And, you know, I guess I would have a question. How does it make sense to only allow the association to follow that, not the managing agent?
And Your Honor, I think because so many of the AOAOs are run by managing agents, that if you allow managing agents off the hook, then you're essentially eviscerating the entire import of subsection E, which says if you're downloading, you don't make people charge it.
All right. Anything
Thank you.
further? No?
No, thank
All
you.
right. We'll hear from Mr. Louie. Thank you. Mr. Louie, we went over a bit with Ms. Bronster, so if you need more than the 1 minute and 20 seconds you have left, or 40 seconds, you can go over a bit if you need to.
Let me be very quick then, Chief Justice. First off, plaintiffs did not file a cert petition, so all of those other issues are gone. The only thing is the ICA opinion here. Number two, I disagree with my friend here that these obligations were on the managing agent under the prior statute before 154.5 was enacted in Act 188. Act 188 placed specific duties on the managing agent and included the new word information as to the duties of what had to be made available. I understand you could read that broadly. I think you should read it more moderately. But
Well, 152 does require information already, right?
that is true. It requires it to be kept, okay? It's on the association. It's just on the association on 152, not on the managing agent.
But what about 154 subsection D that says the managing agent shall provide copies of association records maintained pursuant to this section and section 514B 152?
Correct, and that duty is to provide copies of the records, copies of pre-existing records, not to fill out questionnaires, not to answer questions, just provide copies. And so we don't think that those duties existed until Act 188 and the inclusion of the word information. And the question before you is, do you read that broadly or more moderately? I think in a practical sense. I would like to note on the costs that the costs in this case are approximately $471. Yeah, it's a little bit difficult to find, but Ms. Pembroke, in her deposition, said that the cost of the RR was $185. The actual document of the RR, I'm sorry, the charges were $360 for the package, which included the documents, 197 pages for the condominium documents, the declaration and things like that. The RR document was $185.
Where does the 1,145 come from?
That's for everything for the PKA, the Poipu Kai Association documents, which is not part of this. Yeah, there were two different associations. So there's a $286 charge for the Regency documents, okay? And that was like 1,000 pages. That came out to something like 20 cents a page. It's less than $1 a page. The statement of, but the two documents that they're worrying about are the statement of account, I'm sorry, which was $286. And that's just this, 2 pages, but there were 2 updates for it, so it was additional. And then the RR document, which is a 7-page document, which was $185. When you put all of those together, and it's hard to find out because the original charge for the Regency documents was $360. But you have to minus out the $185 and you get some number for it's roughly $200 $200 for the actual Regency documents and things like that.
You read the statute as allowing the association to impose a reasonable administrative
Yeah,
fee.
so that's the clarification.
And where do you find that?
So 105D, which is what the intermediate court, I think, got partially right, allows a reasonable charge where a managing
What was that
agent.
site, 150?
105, 514B dash 105D specifically states that, when a unit owner requests legal or other information, the board or the managing agent shall be charged, can charge the reasonable cost for that, as long as it's posted, basically, and then the owner has the choice of walking away from that.
When the documents were requested, are the owners provided with, or the documents or the information is requested, are the owners provided with notice that they will be charged this 286 for the statement of accounts and 185 for the RR document, so that they can make the choice of whether or not they want to try to do the calculations themselves?
I believe the owner's agents are, because the owner
Is
never
that in the
got
record
involved.
anywhere? Is that
Excuse
in the
me?
record anywhere?
It's in Pembroke's deposition, which I gave the site for, and
Okay.
it's also in Ms. Geel's deposition. Mr. Caven's deposition also said he didn't make any attempt to actually get any of these documents. And his answer
As a practical matter, the realtors don't really want to do all of this themselves.
exactly, and they're the ones who ordered this stuff. So they're the agents, but I think it is within the scope of their agency to actually order these documents and to do it. But they can choose not to do that.
Can you clarify the total number of pages for the two different associations? Do
So
you
there
have
were
that?
197 pages in the Regency documents, and I believe the PKA documents, I'm sorry, I don't have that right here, but it's approximately 1,000 pages.
Oh, okay.
Does the record reflect, do the depositions indicate that the realtor also requested the standard condominium documents, the declaration itself?
Yes, that is reflected in the realtor's deposition, Ms. Pembroke's deposition. Because what they do is they order a package. There's 10 different things you can ask for, and what they asked for was the complete documents package, and then they checked off the RR.
Is the realtor a part of this lawsuit? Has the realtor ever been a part of this lawsuit?
No, just a witness. Just a witness.
Anything to sort of wrap
Just-
up?
Just the final thing to say is that, while I think, again, I don't want to reiterate the reading of the word information, whether it should be read broadly or moderately, but I think the most important thing is that you can't put, I think it would be wrong to place the duty of download of the internet for free on the managing agent, where the statute 154.5E specifically says association. And the legislature knows the difference between the association and the managing agent, and that duty is not on the managing agent, and thus it's going to lead to absurd results, and it's going to slow transactions down, and it doesn't respect, either the undisputed facts here or the realities of the marketplace. But thank you very much for your consideration.
Thank you to both our attorneys. Today, the court will take this matter under advisement.
Eku iluna, please rise. Ua ho'omololo ia mai ne kea aha ho'okolokolo ki ike hano. This Honorable Supreme Court is now recessed.